Chris Farfoy.
Thank you very much. I'm very happy that the other side is very happy that I'm taking a call on part 4 of this bill. Mr Chair, just to respond to some of the performance from the Minister, because that's all it was. It was just a performance. Don't believe the hype from that Minister when she says this bill is about the care and protection of kids. It's not about kids, it's about cutting costs.
That's right.
Pure and simple. That's what this bill is about. And the Minister said that this bill is about kids and her contribution and that there will be fair representation for them. But, Mr Chair, the Christchurch Family Court judges in their submission to the Select Committee didn't think so. And I'd like to quote from their submission to the Select Committee about the representation of children, and I quote, about family court lawyers representing children. In fact, those lawyers representing children are the single most effective agency in the entire court system achieving solutions for the children. They, and they listed, are mobile, intervene rapidly, are well trained and experienced in their field, gather information, give directive advice to parents, have earned the confidence of parents. The judges go on to say, at the end of their submission, they are the machinery which enable us to make safe, appropriate decisions for children. They are the eyes and ears of the court. Without full participation when needed of the child's lawyers, judges will not be confident they can make decisions which keep children safe. That is a submission from family court lawyers in Christchurch. Mr Chair, this bill is not about primarily about the care of children. This is about the cutting of costs. And as a number of my colleagues have already alerted to in the regulatory impact statement which the Minister referred to in her contribution, on page 11 on the financial implications of restricting the legal aid available to the family court proceedings, says it will reduce the cost of legal aid in care of children cases by $41.3 million over 3 years. $41.3 million over 3 years, Mr Chair, that this will save by restricting legal aid, not to those who are rich, but as the RIS says, this option only affects those parties who, because of their low income, are eligible to legal aid. That regulatory impact statement and the impacts of this policy goes on to say, a couple of sentences later, this could lead to the represented party's view being put more strongly and create or exacerbate power imbalances between the parties. So basically, they're saying there will be an imbalance of the representation between the parties in care of children cases and family dispute cases. I don't think that's a very good thing, and certainly the family lawyers in my patch don't think that's a good thing either. And also another practical impact that the officials that the Minister asked to give her advice said, a very simple thing, some people may have difficulty completing the forms when they're self-representing themselves. Proceedings may take longer, and a judge may feel he or she needs to see the parties in court more often. So what we're having here, Mr Chair, is while the government says it's wants to save $41.3 million over 3 years, we're going to have a false economy, because the cases that come before the judges are going to be much more protracted, are going to be much more complicated, and the family court system is going to get caught up in itself, and things are actually going to be more expensive by this government wanting to cut costs. Mr Chair, about representation, self-representation, there's been a lot of talk about that and the inability of some parents to, do it in an informed way. The family court judges from Christchurch had more to say on that. They say many of our litigants are disempowered in their relationships, highly anxious, suffer personality disorders, are not fluent in English, or are consumed by anger or frustration on the context of a breakdown of their relationships. We are concerned that without the benefit of the moderating effects of their lawyers, there may well be an increase in violent behaviour by frustrated litigants. So I think I've made this point already in a debate in an earlier part, is what is going to happen is by leaving parties to their own devices and not having them giving them the same access to legal aid that they may have or the counselling services that they may have, the issues between those parties end up getting worse. And I just want to quote from that submission again. We are concerned that without the benefit of the moderating effects of their lawyers, there may well be an increase in violent behaviour, Mr Chair,
Chris
or
Farfoy.
frustrated litigants. So, Mr Chair, here we are with Christchurch Family Court lawyers warning the MPs on this select committee that if they leave this as it is, things may actually get worse in the homes of Kiwis out there. And for the Minister to sit there in the chair and to take a call and say that this is actually going to make things easier or better for families is a complete farce. Because we've got people who deal with this on a daily basis, they see the families, they know the issues, and they are warning us, Mr Chair, that if we leave this as it is, if we have people self-representing themselves, if we don't give them the fair access to legal aid that they have had in the past, if we're not going to give children the representation that they've had in the past, things could get worse. And Mr Chair, I don't think that we want to have that on our heads as parliamentarians. Now, can I just also look at some of the other options that the officials looked at and gave advice to the Minister around the restriction of legal aid. And on page 12 of the very helpful regulatory impact statement, in the impacts, they also said, and this echoes what the judges in Christchurch said, judges are likely to spend more, and this is about self-representation, judges are likely to spend more time on proceedings in which parties are not represented, including managing any power imbalances between the parties. Again, Mr Chair, we've got the officials who are advising the Minister, we've got judges who are dealing with these issues on a daily basis, warning us that if we don't do something about this and the changes that this government is going to introduce to cut costs, not to make the family law court process any more effective or efficient, but they are wanting to cut costs, that things are actually going to get worse for the day-to-day running of the courts. Now, OK, that may make things worse for the day-to-day running of the courts, but what impact does that have in the homes and the families of the people who are involved here? That we've got separation. It's a very difficult time for families. Tempers are high. We may have, as was mentioned in part 2, some kind of financial abuse, some kind of physical abuse that's also in the mix here. We've obviously got children. And when you don't have a level of representation that we've had in the past, that could make things much, much worse, as the judges and the officials have warned the Minister of. So, Mr Chair, I just want to make this final point, because the Minister, in her submission, in her last contribution to this bill, said that this wasn't about cutting costs, that this was about the care of children. Mr Chair, and to the Minister, all the people who are giving us advice and who have submitted to the Select Committee say the complete opposite thing. They are saying that what you're trying to do is siloed, is only about cutting costs, and is going to make life much worse for families and the kids in those families if you go down this path. Not only will it make life more difficult for those families, but you're going to exacerbate problems that already exist in the family law court. Things are going to be much more protracted, the cases are going to be much more protracted, and those cases are going to be much more complex. So in essence, what they're saying is you're creating a bigger mess than you're trying to clean up. So I would hope that the Minister might take that message, other than just cutting costs, thinking about the families that are in play here, thinking about the access to justice that is in play here, and maybe she might want to make a contribution, probably not. Maybe someone from the other side of the House might want to make a contribution and tell us how that plays out for Kiwi families. Because at the moment we've got a Minister in the chair who's saying this is all about the care and protection of children, but all the evidence, even from the judges who are dealing with this daily, her own officials, say this is about cutting costs. This is what this bill is about, cutting costs, not making life any easier for those families who are going through this very, very difficult time.
The question is that the Minister's amendments on Part 4 set out on SOP number 349 be agreed to. Those of that opinion will say aye. Contrary, no. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
13 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes opposed.
Mana.
1 opposed.
ACT New Zealand.
1 vote in favour.
United Future.
1 in favour.
Brendan Horan.
1 opposed.
Any other votes?
The ayes are 61, the noes are 58. The amendments are agreed to. So we move to the question on Part 4, which is that Part 4 as amended stand part. Those of that opinion will say aye. Contrary, no. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party.
13 opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 votes opposed.
Mana.
1 opposed.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan.
1 opposed.
Ayes are 61, noes 58. The motion is agreed to. Members, we come to the debate on Part 5. So the question is that Part 5 stand part.
Mr Chairman.
Andrew Little.
Thank you, Mr Chairman. Mr Chairman, I don't want to